The act of cross-examination. Cross-examination is simply the examination of the other party's witness. That is, after a witness is being led in examination in chief, you as the opposing counsel will have the right to cross-examine the witness. And this happens after examination in chief, like I rightly mentioned. You need to know that you do not necessarily need to cross-examine every witness. When you realize that a witness did not give any information relevant to the subject matter, you do not need to waste your time by cross-examining that witness. And you also need to understand that the aim of cross-examination is either for you to discredit the witness or for you to get evidence from that witness to support your own case. This means that your questions are to be constructed in a way either to discredit that witness, to make the court understand that that witness, the evidence the witness has given earlier, that is an examination in chief, the court should not rely on that evidence, okay? And either you want to get information to support your own case as your opposing counsel, you can ask questions that you would direct to the witness, just to answer questions that will support your own case, to build your own case, to have more strength in your own case. So either of those two aspects, that is what your focus should be on while doing examination, while doing cross-examination. Let me introduce myself. My name is Mary and I'm a practicing lawyer in Nigeria. Please do well to subscribe to this YouTube channel, like this video, drop a comment in the comment section, and if you have any question as well, drop it in the comment section, okay? And please try to watch this video till the end. To perform well in your cross-examination, you need to study the case file, you need to study the witness statements before the hearing date. In Nigeria, in civil cases, we have witness statement on oath, which means ahead of that day, you have the evidence, the testimony of the witness ahead of that day, which you can peruse, study very well, and highlight, write out your questions to help you on that day to boost confidence, to build confidence, for you not to have any form of anxiety, and for you to either discredit, like I mentioned, or for you to deduce evidence that will support your own case. So you need to study the case file. In the criminal case, oftentimes we don't have witness statement of oath in criminal cases, unlike civil cases in Nigeria. But what you can do is to study the case file, study the offense. What are the elements of the offense? Sometimes the people like the Economic and Financial Crime Commission, the EFCC, they often list the witnesses they will bring into court, okay, and the role of those witnesses in the case. So sometimes you will see for the police, you see the IPO, for the EFCC, you see the IO. Those officers, what are the relevant questions you need to ask them as relating to the subject matter, since they investigate that case? So those are the questions you need to have in mind. So you need to prepare, study the case file, study the statement of the witness in a civil case, and in the criminal case, study the elements of the case so that you can prepare yourself, and when the witness is done, you'll be able to ask necessary questions, okay? Also, you need to have in mind that you do not need to ask open questions. Open questions are questions that will allow the witness to give details which will not help you. A witness in the witness box, for example, let's say in a criminal case, you have the investigating officer in the witness box, and you ask a question whereby, can you tell the court what happened or what you know about this case? Definitely, they are going to say things that will support their case. So that is why you should never ask open question. Open question, just like it implies giving a latitude, an opportunity for someone to give full details of the matter. Rather, you are to ask closed question. Closed question, such like a leading question, would suggest the answer. Leading questions are allowed when it comes to cross-examination, okay? So you can ask questions that the witness will not really have the opportunity to start giving details. So ask leading questions, closed questions, questions that will not permit that witness to give details, questions that will only suggest either yes or no to the witness. So that way, in cross-examination, the witness will not use that opportunity to build on what they have said earlier in examination in chief. Another thing you need to bear in mind is that you do not need to ask opinion question. Ask questions that relate to the subject matter. Don't ask for the witness opinion. Oftentimes the court overrules such questions, particularly when the other lawyer objects. The point is, do not ask irrelevant questions. Ask questions that is on the subject matter, and questions that relate to the subject matter. Do not be one of those lawyers that want to bombard the witness with a lot of questions. If the subject matter is about dissolution of marriage, ask questions relating to the ground for the divorce. If it's a criminal matter, ask questions relating to the subject matter, I mean the offense. Don't ask questions that does not have any value to the matter, okay? Oftentimes you see people, there was a time I was in court and I only asked just 3 questions. Like I said earlier, there will be days whereby you will find it not so useful to cross-examine a witness. So because you have just 3 questions highlighted for the witness, doesn't make you to look like a bad lawyer or that you're not a smart lawyer. You don't need to ask 20 questions. Just ask questions that relate to the subject matter. Either you are discrediting the witness, or you're trying to build your own case based on the answer you will get from the witness. So don't make any irrelevant question. Also, do not ask questions to intimidate the witness. Sometimes you will see lawyers in court asking questions, shouting, asking a witness like, that is why you are not a good mother, or that is why you have one accused. Like, don't ask questions to make the witness get angry, to make the witness to be emotionally disturbed in order to answer your questions. No, do not do that. That will not make you a smart lawyer, and as a matter of fact, that will not make you win a case, in my own opinion. So don't ask irrelevant questions. Don't ask questions to intimidate or to bully or to annoy a witness. In the situation whereby you ask a witness a very simple and direct question, and if the witness understands that the answer will favor your case, sometimes you see witness trying to beat around the bush. You don't need to insult the witness. What you need to do is to face the court. My lord, the witness does not want to answer the question. The question is as simple as this: did you see the accused person with a gun? For example, in the case of armed robbery, a weapon is quite important in that case, because we said armed robbery, that is, the person was being armed. So, and if the evidence or the case the prosecution has prepared forward as something like states something like the accused person used a gun, you may find it necessary to ask the IPO, that is investigating officer, that is, did you see the accused person with a gun? That is a leading, very direct question. Instead of asking, please tell the court, or it's very simple when you ask the question, what did you see the accused person with a gun? It is either yes or no. If you're saying yes, a further question can come with, can you please show the court, or do you have before this honorable court the gun? You can't just assert a thing, you need to prove it. Or it is no longer here, we saw him with a gun, but we could not we were unable to arrest him with it, and things like that. So the point is just that ask a direct question, and when you realize that, for example, if the IPO is not trying to beat around the bush, probably because the answer will favor your case, you don't need to annoy, you don't need to insult the witness. Face the court, make the court to understand that you're asking a very simple question and the witness is not helping. So the court would talk to the witness and say, this question is as simple as this: did you see him with a gun? Answer with a yes, I did. I saw him with a gun, or no, I did not. It will be as simple as that, instead of you trying to cause, I use the word commotion in the courtroom. Okay, so that is basically all I have for you in this video. I'll try and come up with another video on a practical way. I would try to cross-examine my colleague, and it will be like a practical one. Like if you're a newbie, a young lawyer, you just want to get it right on how to do it. I started cross-examining witness as my first year in practice. Yes, it was a civil case and I did my best. Okay, so I will try and put up a practical one. I'm trying to come up with practical content myself and a colleague trying to display the whole thing as if we are in the courtroom. Please like, subscribe, and share this video. Thank you.